Okay, ladies and gentlemen, we're going to get started this evening. Thank you so much for being here. It sure is great to see familiar faces, folks that are returning to our event each month, and also new faces. I see a lot of my students here tonight, and it's ironic because I always tell my government students that there's no better date in this world than to go hear a lecture on the 14th Amendment. So thanks for being here, hopefully on a date, right? And hopefully we'll meet your expectations this evening. My name is Adam Brewer, and I teach here at American Heritage, and excited to have this chance to moderate a debate between two of my favorite people. We're going to get started this evening with an invocation offered by Emma Hymas, after which Sarah Pierce will lead us in the Pledge of Allegiance. Emma.
Our dear Heavenly Father, so thankful for this day. We're thankful that we get to be here at this debate tonight, and please us all to be able to learn and grow in knowledge. And we're so thankful for Mr. Hancock and Mr. Hymas and Mr. Brewer and all that they do to put this on for us. And we say these things in the name of Jesus Christ. Amen.
In honor of one nation under God, please stand. Repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. I failed to, I just want to welcome those that may be joining us remotely or that will watch a recording of this meeting later on. Now it's my pleasure to introduce our debaters this evening. David Hancock, as a member of the AHS High School faculty. Prior to joining American Heritage in 2010, David was a practicing attorney. He is a cum laude graduate of BYU Law School and has argued dozens of constitutional issues in court. Jeff Hymas joined American Heritage in 2016 after working with many organizations presenting hundreds of lectures on the Constitution to live audiences across America. He holds an MBA from Idaho State University and is a magna cum laude graduate of the BYU Marriott School of Management. Tonight, we are excited to be discussing the topic of the 14th Amendment, a very relevant topic. We'll first hear a brief lecture from Jeff, who will teach us about the basics of the 14th Amendment and how it operates in our political system, after which we'll do a quick stand and stretch 60-second break while we rearrange the stage for the debate. After the debate, audience members will have an opportunity to ask questions in a Q&A session to conclude the meeting. We encourage audience members to think of tough questions to ask for this portion of the evening. Let's begin by giving Mr. Jeff Hymas a round of applause.
All right. There we are. Okay. It's good to be here. I'm guessing when you heard 14th Amendment, due process clause, equal protection clause, you're like, okay, sounds like a snoozer, but it isn't. It's going to be really good. And I'm going to tell you why. I want to give you, we had some thoughts here. If David were up here, it would be a snoozer. Whoops, did I say that? He would speak to us in lawyerese. We decided that if we're going to talk about this, we have to kind of dumb it down to my level. And so he said, Jeff, it's your chance to go kind of just say it in simplistic terms. So we're sacrificing a little bit of accuracy for simplicity here. So just so you know, there's probably some things I'm going to say that are not like perfectly like in depth, how a lawyer should say it, but Dave will get to that later. But yeah, we were trying to keep this on a high level and pretty simple in order to understand. And then as we get into it, of course, we're going to dive into a lot of depth there. But just thought I'd put that disclaimer out there. So the 14th Amendment, we're going to spend all of our time in just Section 1. The 14th Amendment has 4 or 5 sections, but only Section 1 is the one that is, controversial. It's played, for the most part, played any role, a significant role in our nation's makeup constitutionally. I wanted to start out with a quote this is from a talk of Alan H. Oaks. He's quoting Reuben J. Clark, and then later on he quotes Joseph Smith. So I'm going to read, this is from his talk word for word, but in President Oaks' talk, he's quoting these two people. President J. Reuben Clark, who referred to the Constitution as, quote, part of my religion, unquote, also said that it was not part of his belief or the doctrine of the church that the Constitution was a fully grown document. On the contrary, he said, we believe it must grow and develop to meet the changing needs of an advancing world. That was also the attitude of Prophet Joseph Smith. He faulted the Constitution for not being broad enough to cover the whole ground. In an obvious reference to the national government's lack of power to intervene when the state of Missouri used its militia to expel the Latter-day Saints from their lands, Joseph Smith said, quote, its sentiments are good, but it provides no means of enforcing them. Under its provision, a man or a people who are unable to protect themselves, like the members of the church, right, can get along well enough, but those who have the misfortune to be weak or unpopular are left to the merciless rage of popular fury. Okay, so it's interesting when Joseph Smith said that, he was referring to the need for, essentially, the 14th Amendment. The 13th Amendment, slavery, the 14th Amendment, this idea that we need to have some type of amendment to the Constitution that can cover the whole ground, that can protect minorities, protect unpopular ideas and people and minorities from the fury of the mob. So I thought that's an interesting intro into the 14th Amendment, its purpose. The 14th Amendment then is a going the right direction here. Oh, there we are. Okay. 14th Amendment is a Reconstruction Amendment. It was part of the amendments to address the African American injustices, right? The 13th, 14th, and 15th came together. The 13th was to abolish slavery. The 14th, its heavy provisions with the due process and equal protection clauses. That was in 1868. And the 15th Amendment gave voting rights to African Americans, or effectively to African Americans. It's, to everyone, but that was the intent of it. So what I'm going to try to do is I'm going to try to establish just a basic overview of the 14th Amendment, but also just lay out some differences at a very high level, what you can expect to see later on in the debate and as we present here. In general, I see the 13th, 14th Amendments as being very focused on a specific purpose historically, which was to right the wrongs of African Americans. Okay, and I think Mr. Hancock, he'll speak for himself later, but he's more of a, no, this was not just a shift in that, but it was a shift more globally, right? More intentionally for the makeup of the Constitution and other provisions there. It's well established or well believed or understood that it was a major shift away from the states' rights doctrine. Okay, now it was also fairly well believed or popularly believed that it's kind of a second founding. The 14th Amendment, the 13th, 14th, 15th kind of changed America fundamentally. Now, whether that happened, to what degree it happened, and whether it was good is something that Mr. Hancock and I disagree on. But I think generally most people, whether they're conservative or liberal, would say, and not saying that Mr. Hancock's Mr. Liberal and I'm Mr. Conservative, just say, I think across the board most people say, yeah, it was a shift away from the states' rights theory. And it was kind of a second founding, kind of a reestablishment, a different twist on how America started to look at the role of the federal government as opposed to the role of the states, which is much stronger previous. It introduced the doctrine of incorporation. The doctrine of incorporation is when you incorporate or you apply the Bill of Rights to the states, not just to the federal government. Because the Bill of Rights, a lot of them start out with Congress shall not, or they're referring to Congress, and Congress obviously is a federal level. And the 14th Amendment is the first one that started to say, wait, we're going to apply these restrictions that we've only applied to the Congress, we're going to now apply those to the states. The 14th Amendment put that in process and has become the bedrock upon which a lot of court cases turn back to. Because of the indoctrination doctrine brought about by the 14th Amendment, we can now apply the restrictions to Congress and to the states. So it brought that into fruition. And it's one of the most litigated parts of the Constitution. Not only now, all the big cases now are really, a lot of them come from that 14th Amendment, due process and equal protection. But also historically, I mean, the big cases that we know about, Plessy v. Ferguson, right, separate but equal, Brown v. Board of Education, which reversed Plessy v. Ferguson, Roe v. Wade, Obergefell versus Hodges, all those really are fundamentally a 14th Amendment question. And so it's, even though we kind of hear 14th Amendment and hear Equal Protection Clause, like, what does that mean again? It's super, super relevant to current events because those are the big issues that are debated a lot. And you'll see why, I hope, as Mr. Hancock and I debate this. All right, I have a feeling I'm not really controlling this. All right. Okay, 14th Amendment. So what we're going to do is we're going to walk through Section 1 briefly, and we're going to read every word of Section 1. There are only 4 little clauses that or sections we're going to talk about. But I wanted to make sure to hit those so you could look at them. Some will be more emphasized in the debate and some will not. This one probably won't be as much, although it could be. We could come up with this if we wanted to. First part, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Okay? This is where you get this idea of birthright citizenship, or what's pejorative, anchor babies. I didn't know that was a pejorative. There we go, anchor babies. I thought that's just what everyone called it, but apparently it's a pejorative, but I think it's a well-known term, this idea of birthright citizenship. Well, as long as you're born on American soil, you're now a citizen. And that's debatable. Mr. Hancock and I have different, well, it's not really debatable, it's settled at this point, but that doesn't mean I don't want to debate it. I have a different view on why that should be there, and Mr. Hancock probably agrees more with the prevailing view. But that's the first part of Section 1. It talks about birthright citizenship. Good. Second part, privileges or immunities clause. It's what this one says. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay? It's really not a clause that's used very much anymore, partly because in black and white language, or at least this is what's been interpreted, the privileges and immunities is tied to citizens of the United States. It's not really a controversial or is this an indoctrination, not indoctrination, the incorporation? Well, no, the courts have ruled that from way back in the slaughterhouse cases that this doesn't apply except to federal government, and therefore it's not as controversial, and this isn't used that much. So we won't really spend much time here. Although people like Justice Clarence Thomas say, no, this is where we spend all our time. We shouldn't spend our time in due process. We should spend our time here. And I think there's certain validity to that. Due process clause, this is where it starts to get a little more hot, a lot more hot. Okay, this is a big issue. Here's what it says. Nor shall any state deprive any person of life, liberty, or property without due process of law. Okay? Due process is a fairly straightforward term, except it's not at all. Okay? You get procedural due process, which is, in my mind, like it's kind of a reiteration, right? Procedural due process, like process due process, as opposed to the next one, which is called substantive due process. Procedural due process, it says, is the process working to protect people's rights? We got to make sure the process is fair so people are treated right and their rights are protected. Substantive due process is a little bit different. Substantive due process says, and I have my notes here, but I won't be able to pull up. Dave would give you a lot better lawyer-esque definition, but substantive due process says, look, there are things that are substantively there. There are rights that we agree must be there, must be protected, and they may or may not, well, probably aren't really enumerated, aren't really listed anywhere, but it's obvious based on the due process clause that they should be protected. So they're created, it's kind of a mechanism of the courts to say, we're going to say the substantive due process exists, even though we can't necessarily point to it. Substantively, it's there, so we need to apply the substantive due process to do that, okay? And Roe v. Wade is not the first time or the only time that's been applied, but it's the most popular and easy to conceptualize the application of that. Because essentially in Roe v. Wade, if you know that, I've followed it a little bit, the court said, we're going to find somewhere in the 14th Amendment, the due process clause, we're going to find the right to privacy, which equates to the right of a woman to abort her child. Even though it never really talks about that, even though it never really says that, we're going to say substantively, we're going to apply it that way. Is that fair enough? In simplistic terms? Okay. Lastly, the Equal Protection Clause. Nor deny to any person within its jurisdiction the equal protection of the laws. And this one really, in my mind at least, in my opinion, is the one that gets debated a lot because of this first point. It's really the basis for discrimination cases. In discrimination cases, there are a lot of those nowadays, right? And their basis is, hey, I'm not being equally protected. That's the basis for all the discrimination cases, okay? Next, it's really a good, interesting one because it's a tricky balance with a lot of different things, but one in particular, I think, is the freedom of religion. Are we going to equally protect this class or who they are or what they want, or are we going to protect this person's religious liberty or religious freedom? And that balance creates a lot of friction, creates a lot of lawsuits, creates a lot of calling on the Supreme Court or Congress to make decisions about what does this mean? Where are we, and how does this work? But that's a really interesting one. The Masterpiece Cake Shop, right? The man the business owner in Colorado who refused to make a cake for a gay couple, that became a big highlighted case. That was all about the due process, not the due process, Equal Protection Clause of the 14th Amendment. His expression of his religious rights, right? The Amendment 1 that says he has the right to exercise his religious beliefs, and then Amendment 14 where it says, yeah, but we need to equally protect the class of this new protected class of gay marriage, etc. Okay, and then Obergefell v. Hodges. That's the classic gay marriage case where we're saying should everyone have the right to get married, and you'll find that Mr. Hancock and I, in a lot of cases, we actually arrive at the same point. We actually agree. We're both against Roe v. Wade, and we're both against Obergefell versus Hodges, but we both have different ways of getting there, and substantively, different reasons why. And I think that's what we find that's kind of interesting. Well, one thing maybe I'll just throw out there, and I think Mr. Hancock and I have talked about this, but we're both in agreement that everyone really does have the right to marry. There's no question that everyone should have the right to marry. The question is that it shouldn't be a carved out free right of someone to redefine the definition of marriage. That's the real question, not whether everyone should get married. Everyone can get married. Any man can get married to any woman can get married to any man. But not any man and woman can choose to change the definition of marriage to their liking in order to get something they want. That's what they don't have the right to do. So throwing that out, there's those four parts, right? The birthright citizenship, there's immunities and privileges, there's due process, and there's equal protection. And those are the things that are going to form the basis for our debate today.
Okay, we'll just take our 60-second stretch break while we rearrange the stage.
You go ahead. It's kind of loud.
Okay, thank you, Jeff, for your lecture this evening. We're excited to have this opportunity to debate the 14th Amendment. It's clear that there are some differences between our two debaters. I wanted to first just ask a question to David this evening. Can you just clarify why was the 14th Amendment deemed necessary, or the shift away from states' rights deemed as a necessary thing to the Congress at the time when they passed it after the Civil War?
Yeah, I think that the biggest reason that the 14th Amendment was deemed necessary is because from the institution of the Constitution up until the beginning or basically the end of the United States Civil War, the states had enjoyed this power of states' rights, of self-determination, and a great deal of ability to operate in the way that they felt was best. However, the result of that was a great deal of what the people of the United States viewed was abuses of states' rights. The state governments overexerted themselves. They denied the rights of various individuals, and this all comes to a head in the decision of the Dred Scott case, where Chief Justice Roger Taney basically says that African Americans have no rights that any white man needs to respect, and that they could not and were not citizens of the United States. That is one of the things that leads off to the Civil War, and at the end of the war, with the suspension a lot of the political rights of the southern states, Northern Republicans decided that they needed to make sure that these rights were protected for the rest of time. And so they proposed and instituted a series of the Reconstruction Amendments, the 13th, which outlawed slavery, the 14th Amendment, and the 15th Amendment. And what these did is put in place a new structure whereby the rights of states for their self-determination, for their ability to go contrary to the federal government, was greatly restricted. They were greatly reduced. And in exchange for that, that power that was taken away from the states was then expressly given to Congress to exercise instead. So when you look at the 14th Amendment, you look at Section 5 of the 14th Amendment, it says something for the first time in the United States Constitution. It says that Congress shall have the power to enact legislation in order to enforce these amendments. And that is an enormous grant of power to Congress. And so when you look at Article 1, Section 8 of the United States Constitution, Jeff always likes to talk about the enumerated powers. And one of the most important enumerated powers for Congress isn't in that Section 8. Instead, it's in Section 5 of the 14th Amendment. So it's a huge shift of power away from states and towards the federal government.
And do you mean in the state's ability to treat people differently before the law and to not provide procedural or perhaps substantive due process to people based upon, for example, race, which was what the states were doing?
Yeah, and you look at basically the First through the Eighth Amendment, all of those applied. I think Jeff pointed this out earlier. All of those applied only to the federal government. So, for example, there was no freedom of speech in a state. A state could theoretically restrict speech. States had established religions. States could do all of the kinds of things that today we think are general prohibitions against government. But those prohibitions only applied to Congress, not to state governments, not to counties, not to cities. And as a result of that, you see what happened in the 1830s and 1840s with, all the way up until the 50s, with the Church of Jesus Christ of Latter-day Saints being driven out of the state of Missouri, Governor Boggs' extermination order. All those things were made possible as a result of there being no 14th Amendment. And as a result of that, in a state, there was no religious liberty. And so the 14th Amendment for members of the Church of Jesus Christ of Latter-day Saints in particular is really an important time where the protections of the First Amendment were applied to them for the first time to individual states. Now, it took a while for the 14th Amendment to take place, and I'm sure we'll talk about that, but it even though it was ratified and made a part of the Constitution, it took quite a while before the rest of the country kind of caught up with the 14th Amendment.
A question for Jeff. So, Jeff, in your lecture, you mentioned that you see the adoption of the 14th Amendment in the context of the time, and that perhaps interpretations outside of that context we should be wary of. Can you provide a little bit more elaboration or clarification in terms of that thought there?
Yeah, I'd like to think that my thinking, if you've been to other presentations, that my thinking is consistent here. I don't know, to me it seems consistent. I'm big into original intent. I don't think the 14th Amendment or the 13th or 15th were made in isolation. They're made, thank you, they're made based on this issue at hand. And the issue at hand was the mistreatment of African Americans, what rights they were getting neglected or, infringed upon. And so I think that's really, really important. So I might even, say Joseph Smith said the Constitution didn't go far enough. And I totally agree. I think the 14th Amendment was very necessary to make sure that religious minorities and others had the protection from their state governments, that they now had to apply the Bill of Rights to the state governments. but I would maybe amend or add on to Joseph Smith's quote that if the Constitution didn't go far enough, I would say the new interpretation of the 14th Amendment went too far. Like I think we did need to swing the pendulum. It was all states' rights, and they were doing bad things. They're persecuting, killing, and just completely getting away with it, right? Even to the point where Joseph Smith goes and talks to the president and says, "Hey, we need some help here," and he's like, "I can't do anything for you," and he couldn't. Constitutionally, he couldn't. The Constitution didn't allow him to step in there and tell the states what to do. So we did need to swing the pendulum back. My concern is that the pendulum has gone all the way to this side, and the original intent is not being honored anymore. And we've taken issues that really weren't intended to be talked about or addressed in the 14th Amendment and said, oh, we're going to apply this new issue that really doesn't have to do with the 14th Amendment, but we're going to go ahead and apply it to the 14th Amendment. I don't think that's the best way to govern. I think the point of amendments is to address the issue at hand. So these new issues that are coming down the pipes, I think that we need to stop and address them through Congress. And if they can't be addressed through Congress, they need to be addressed through an amendment and not just turning to the 14th Amendment, kind of squeezing out of that. I think this is what it means, because I don't believe there's any. I think you could do this, but I don't think it was the intent. I don't think it's appropriate to say, let's apply 14th Amendment language to gay marriage or to abortion, because that's not really what the 14th Amendment was about. And when you do that, you can get in trouble. And so I feel like kind of the same consistent argument I've had before is when the Supreme Court is the one saying, here's what the 14th Amendment means, what they're doing is they're saying, we're going to essentially legislate from the bench and say what the 14th Amendment means. I also think there's a challenge with the 14th Amendment getting so strong that it actually overrides the First Amendment, the freedom of religion, or it actually overrides the 10th Amendment, which is, there's still states' rights. The 10th Amendment still exists, right? The powers delegated to states by the Constitution, or not, powers delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the people or the states. That's still there. It's not like the 14th Amendment wiped that out. Or it's not like it wiped out the First Amendment, the freedom of speech or religion. And so I think we've got to understand it's an important puzzle piece. It really needs to be there. But if you go too far, then you end up having just as many problems as overpowering, overbearing states. You now have overpowering, overbearing federal government.
Thank you, Jeff. I understand, David, that you see the passing of the 14th Amendment a little bit differently in terms of its implications. How so?
Well, the 14th Amendment, keep in mind that when you're amending a constitution, any amendment amends everything that comes before it. So to the extent that there is some inconsistency between the 14th Amendment and the first 13 amendments, there is certainly an argument to be made. Well, the 14th Amendment amended all of that. And that's something to keep in mind. And the other thing that I really see the 14th Amendment doing is you have this really complete restructuring of the doctrine of federalism. So we talked sometime quite a while ago about federalism and the way that federalism works and this tension between the states and the federal government. And the 14th Amendment drastically alters that tension. And if you will, it's like somebody putting their very significantly sized thumb on the scale on the side of the federal government. And that what I see the 14th Amendment as doing is this really vast grant of power to the federal government, and this ability for the federal government to pass laws over a really quite a broad range of things, because what the 14th Amendment covers encompasses or incorporates all of the first 10 amendments. And so part of the argument that I think people sometimes make of, like what that Jeff has made about originalism and the 14th Amendment, that's not what the 14th Amendment says. And the 14th Amendment, I think from a textualist perspective, which is what I tend to do, or a structuralist perspective, should be interpreted more as meaning what it says and saying what it means. And that it truly does restrict the power of states and grant broad powers to the federal government.
And just to clarify, David, you suggested that the 14th Amendment essentially amends all of the preceding amendments. On what basis? Was it the people who were writing the amendment were under that impression? Was it the states who approved of the amendment? On what basis can that suggestion be made?
So when you take a look at the Constitution, so the Constitution at the time that the 14th Amendment was ratified in 1868, it existed with the 1st through 13th Amendments. And those were part of the Constitution. And so when you adopt the 14th Amendment, anything inconsistent with the 14th Amendment is now amended and repealed. So you look at other amendments to the United States Constitution. So you look at the 12th Amendment, for example, regarding the election of presidents and vice presidents. It doesn't matter that we can point to Article 2, Section, what is it, Jeff, 2? Article 2, Section 2, that talks about how the vice president is the second runner-up in a presidential election. That no longer matters because the 12th Amendment has removed that. Now, we decided that we were going to keep the language of all the original parts of the Constitution and list amendments as tacked on the end. And there's a lot of good reasons why I think we made that decision. But the reality is that those provisions of the Constitution cease to have any impact. So, for example, the 14th Amendment modifies and changes and eliminates the 3/5 compromise, which provided that people who are slaves would only be counted as 3/5 of a person for purposes of congressional representation. Section 2 of the 14th Amendment eliminates that and says that no, they're counted as a whole person. And that if they're not entitled to vote, then or they're not allowed to vote for whatever reason, that the state will lose that count. They don't get to inflate their power by denying voting rights to individuals. So you have this amendment of everything that comes before it. And so to the extent that there are conflicts and if those conflicts are evenly balanced, I would give precedence to the 14th Amendment rather than other amendments.
Interesting. Thank you, David. So, Jeff, essentially, David's suggesting that the 14th Amendment is a quote-unquote second founding, right, of our Constitution. Do you think that that might make people feel a little bit uncomfortable? What other arguments would you make against that notion that the 14th Amendment really overshadows all the preceding amendments?
Well, I think I'm often sitting in the seat of saying, well, that is what happened, but it shouldn't have happened. I would repeat myself here. I think that is what happened. I think it's hard to deny that the 14th Amendment was a major shift, a major change, and one that I don't think was appropriate, nor is appropriate now to consider. We did need to swing the pendulum back, but to say, yep, that's why we're over here and this is good is super dangerous in my opinion. I don't know, it'd be interesting, I didn't know you thought, I'm still trying to interpret how far you're going with this, David, but part of my question is, so are you saying the 14th Amendment overrides freedom of religion? I don't think you're saying that. Or are you? You're not saying that.
Well, what I'm saying is all things being equal, the 14th Amendment prohibits essentially discrimination on the basis of race.
Right.
And what we have decided as a country is that if freedom of religion conflicts with the belief of racial discrimination, the prohibition of racial discrimination wins and freedom of religion loses. So what I would say is when you look at certain things, what you do see is the 14th Amendment does trump those things.
Yeah, I would disagree. Maybe not going down the idea of race at this point, but if a state, I guess my challenge is, I think that what happened in the 14th Amendment is that it provided a good balance, and it put federalism how it's supposed to be. It didn't eliminate federalism. I think that's the problem of, at least maybe my interpretation of the extreme side of what Mr. Hancock may or may not be saying. But is if you do that, then you say the federal government is now in charge of everything. All cases religious, all cases marriage, all cases, all these different things. No, that's not America. America's not, the federal government now is in charge because the 14th Amendment said it. They're in charge of everything. It's no, we still have federalism. You still solve the issue at the lowest level of government possible, and you never go to a higher level of government when you can solve the issue at a lower level of government. So even though that's in place when it needs to be, like in the case with the members of the church in Missouri, and the federal government should have stepped in. They didn't because historically we left, etc. But it would have been nice if the federal government stepped in and fixed that. but it still needs to be fixed first at the state level. Like, I think that's why the recent ruling with overturning Roe v. Wade put it back in the states, is because that's how it's supposed to be. It's supposed to be federal, and it's not supposed to be the federalism. Okay, we always get confused. Federalism, it just means different layers. It's division of powers, the vertical division of powers. It's not to say, the 14th Amendment doesn't say the federal government is king. It says the federal government needed to be strengthened and get in its proper place, which it was, and I think it's gone too far. And that's I think it's a little dangerous to say that. It's interesting. I'd have to think about that a little bit more, but to say the 14th more or less kind of trumps the 1st or the 10th, to me feels like if it says it explicitly, in Section 2 it talks explicitly, it refutes the idea of a slave being worth 3/5 because there is no slave anymore, etc. I think it's pretty clear. It's refuting that provision in the original Constitution. But when it doesn't say specifically, I have a really hard time saying, well, we're going to go ahead and say race is more important than religion if they kind of come head to head. And I certainly don't want the federal government nor the Supreme Court to be the ones making that decision. I think in an American system, there needs to be freedom, and the layers of federalism, what protects us from an overbearing 14th Amendment. And we go back to the topic we had last time in October. Man, if you say, well, then we're going to let the Supreme Court make the decision, well, then guess what the Supreme Court's going to rule? They're going to rule in favor of the federal. Of course they are. But that's I think, a bad default. I think we still need to follow federalism.
So Jeff, considering the fact that you're dissatisfied with the way the 14th Amendment has been interpreted, just recently in the Dobbs decision that overruled Roe versus Wade, in one of the concurring opinions, Justice Clarence Thomas suggested that the 14th Amendment should essentially be interpreted as such, and that really most issues should be handed back to the states. What that would mean is that states could still potentially make illegal interracial marriage, or make illegal gay marriage, or make illegal or legalize abortion, right? How do you feel about some of the consequences that might come about from kind of contracting that interpretation of the Supreme Court? If the Supreme Court continues to kind of limit the way that and bring these issues back to the states, what that could mean for American politics.
Yeah, and to extend your question, you could say, well, Jeff, do you believe that the federal government should be able to persecute, or states should be able to persecute religious minorities, whatever? That's kind of the same idea, right? What I think is America is set up as a United States of America, and those states are laboratories of freedom. And I think if you're to follow, I believe you follow my logic, you'd say you can't have one or the other. And I'd say, yeah, I'd rather have the inconveniences of states making inconsistent rules about abortion or gay marriage, etc. And then within those states, we see how that plays out. And states who attract people who don't believe that, they believe that's a moral issue that shouldn't be tampered with, they won't live there. They'll go live in states that do protect marriage. They'll go live in states that do protect babies from abortion, etc. And we'll start to see, and we'll really see, does the morals of that state, does it play out? Does it play out in the economics? Does it play out in the freedom? Does it play out in these different areas? And I think allowing those states to have that freedom is essential to federalism. It's also essential to freedom. So in some ways, when Roe v. Wade said, no, Texas, you can't say you can't have an abortion. You can't have a law that says you can't have abortion. When the Supreme Court said that, and basically said, okay, the whole United States, you can have abortions now. I'm obviously against that. But in some ways, I'm kind of against saying, well, that the Supreme Court should rule that it's actually not the Supreme Court's call. It's the state's call, and they should make those decisions at the state level. Even though I don't like some of the decisions the states will make, I think the freedom is important. And in a Republican system, it'll play itself out. And it's a fairly libertarian idea. Are you sure you're really fine with the federal government doing nothing and letting some bad things happen? And I'd have to say, well, yeah, I think so. I think that's how it works. I think freedom's a little bit scary. It's not just cushy, and if you get everything you want, then you have too much control, and you're going to ruin the goodness that could be brought about by freedom.
Right. So even if New York were to legalize abortion up to essentially pregnancy, right, and Mississippi or Texas were to do the exact opposite, you would be fine with that based on that principle.
Sad, but fine. Yeah. Sad, like, oh, I wish they wouldn't do that, but fine with it based on the idea that, yeah, it's a state choice, they're making a choice that's just super poor, and it's going to play out. I'm sure it'll play out. You don't get away with stuff like that without having consequences. But unfortunately, they do that, but they totally justified constitutionally, justified in my view of the principles of freedom.
Right.
So I have a different view. I'm sure that's shocking to everybody. The 14th Amendment guarantees certain, or provides certain guarantees for life, liberty, and property, that they be equal across the entire United States. And so this is where that second founding to me comes in, is the reason why the 14th Amendment was adopted in the first place is because states said we should be entitled to make laws the way that we want to make them. We should be able to decide what is the way that things are going to work within our state. And they were abusing that power. And as a result of that, the 14th Amendment was enacted and took that power away and expressly gave it to Congress. So this is one of those things, I say this sometimes, that, we get to decide what our actions are, but we don't necessarily get to decide what the consequences of those actions are. And states were misbehaving. They were doing things that were wrong. They were denying liberty, they were denying life, and they were denying property to people who were born within the United States. And as a result of that, the 14th Amendment was adopted and a significant grant of power. Now, one of the things where I think that we can talk about is, what does life, liberty, property, and equality under the law mean? And I think that those are some things, as well as privileges and immunities. I do disagree with Jeff a little bit that's an old thing. I think that's still very much alive and well. But those are some interesting ideas to me as to what does life, liberty, and property mean, and what does equal protection mean, and what do privileges and immunities mean. But those have been guaranteed by the 14th Amendment and have been granted, and the power has been granted to Congress to enforce and to protect those things. So states no longer have the ability to just say, well, that's the way we want to do it. And I think that one of the biggest places where the 14th Amendment overruled other amendments is in the 9th and 10th Amendments, where powers are reserved to the people and powers are reserved to the states. Because the 14th Amendment basically says, yeah, well, not anymore. And that we're taking a big part of that chunk and we're handing it over to Congress.
Yeah, I just, when you go to the language, this isn't a fully developed thought, but the 10th Amendment to me is like super sacred, like it's super important. So to hear that the 14th Amendment kind of overrides that, so that the power is not delegated to the United States by the Constitution, nor prohibited by it, meaning the Constitution, to the states, or reserved to the states to effect the order of the people. To me, I don't think the 14th Amendment just erased that.
So I'm going to say 14th Amendment, Section 5 says, Congress shall have power to enforce the provisions
and due
of
process.
this, which is equal protection, privileges and immunities, due process under the 14th Amendment.
Correct, yeah, and I would say that's true. But then, so I guess, if you take what you're saying just at face value, and I could extremify it, if that's a word, make it more extreme, you're basically saying we don't really have states anymore. And they give state driver's licenses, and they have state cops and stuff, but really it's just a federal government. They just kind of run the show, and that is what happens today. But I would say that's not a proper. To me, an amendment is amending something. What is it amending? Well, there's certain things it says it's going to amend. And the fact that it's saying, yes, the federal government can step in when it comes to equal protection or due process, that doesn't mean they're the ones who are supposed to be in charge of everything that happens now. It has to do with anyone's rights anywhere along the line. The 14th Amendment didn't say we now dissolve states except for technical little things that no one cares about. It didn't say that. It said, and it was specifically originally intended to deal with the slavery issue, to deal with the African American abuse of rights. I just have a hard time. It just goes way too big for me, and I don't think anyone would be comfortable with that. And I think we need to rein it back in, because otherwise we do get into, now when you start to talk about current events, gay marriage or abortion, we start to see. I think we start to see the evidence of what an overinterpreted, overextended 14th Amendment can do. It can do a lot of stuff that we're like, wait a second, how is that our decision? When Roe v. Wade, when 80% of America is against abortion, and yet they're able to say that you can have abortions, like, because of the 14th Amendment? Well, hold on, what's governing us here? Are we governing ourselves, or is this interpretation of a law governing us, which I think is inappropriate? I think we're no longer self-governing. We're kind of being guided by interpretations of what someone thinks this means. I don't know if that makes sense.
The way that I would respond to that is when you look at the 14th Amendment, it's structured in an interesting way. The first thing that it says is all people who are born in the United States are citizens of the United States. And there is a historical reason why it says that, but it goes beyond that. It means that every person born in the United States is a citizen of the United States and now entitled to all and full rights of citizenship. And that's an important thing to keep in mind. The second thing that it says is that a state cannot deny the privileges and immunities of a citizen of the United States. So if there is a privilege or immunity from being a citizen of the United States, in other words, if there is a right that you're entitled to as a citizen of the United States, a state cannot prevent you from having that. Secondly, they cannot deny life, liberty, and property without due process of law. And then fourth, they must provide equal protection of the law. In other words, you can't treat different citizens differently. It has to be even. If you're going to treat Jeff one way, you got to treat me the same way. And so, and this all comes out of that abuse of state power that existed in the past. So from a structural perspective, you look at that and you can see that the amendment is creating a clear argument that citizens have certain rights, that states can't deny citizens of those rights, that if they attempt to deny those rights, they have to do it through due process of law, and we'll talk maybe later about what that might mean. And secondly, they have to provide equal protection. They have to provide this equally all the way across the board, and you can't treat, as I would say it as a lawyer, similarly situated people in a disparate fashion. In other words, if you're in the same circumstances, you can't treat two people differently. And so to me, it really is a very logical and express thing. And then Section 5 says, look, and this power is being expressly given to Congress. And so when I look at the 10th Amendment and it refers to powers not delegated, well, 14th Amendment clearly delegates that power to Congress.
So just to follow up, David, states are passing laws all the time, granting some rights to their citizens, and you're seeing this, you're kind of seeing a proliferation of this as, states like California or Florida or, conservative and liberal states really view rights differently and grant a certain privileges or rights to their citizens differently. Are you suggesting that the 14th Amendment essentially supersedes a lot of that, and that really there should, when it comes to equality before the law, states really don't have the purview to treat citizens differently because they are U.S. citizens?
I would say that they're not able to treat people differently if they're U.S. citizens, but if it's not what we would call a federal right, then they can say this is what your right is within the state of Utah. And they have to treat everybody in the state of Utah the same, whether you're a resident of the state of Utah or a citizen of the state of Utah, or whether you're a resident or citizen of the state of California. I'm saying resident or citizen because those two terms are sometimes confused. But you can't say, oh, we're going to treat our Utah residents one way and we're going to treat California residents differently. So for example, one of the earliest decisions under the 14th Amendment had to do with the right to travel, the right to go from one place to another place. And a state tried to restrict people from another state coming into their state. And the court said, no, you can't do that. Now, keep in mind that before the 14th Amendment, states could actually do that. They could prevent whole classes of people from coming into the state, mostly African Americans. But now they're saying, no, you can't do that. That is a right of a federal citizen of the United States, is the right to travel. And so when we go from state to state in the United States, we don't have to have a passport. We don't even have to have a driver's license. We can just travel within the United States, and we can cross, state boundaries all the time, and another state cannot prevent us from doing this. This is something that I've often thought about as I drive from Utah to California, or from California to Utah, and I pass that agricultural inspection station. I don't know if you guys know what I'm talking about, but as I've gone,
closed. The one that's closed because California's bankrupt.
it's either closed or it's just wide open and people just go right across it. But it's one of those things where I've often thought, they could potentially take away my produce. So if I had an orange that was from the dread state of Florida, and I'm trying to drive it into Southern California, they could confiscate that orange, but they can't prevent me as a person from crossing that border. Which I always thought was ironic, because when I was growing up, and until only a couple of years ago, it was about 70 miles from the California border. But
Well, and I think there is a precedent even before the 14th Amendment for that. The Articles of Confederation actually states, or basically provides, and I can't remember which section it's in of the 13 sections, the right to freely travel between the states.
But that didn't apply to all people. That only applied to citizens of the respective states. And keep in mind, this is where Dred Scott comes in. And this is why the 14th Amendment was enacted. It's because Dred Scott said that the black man has no rights that the white man need respect or honor. And the 14th Amendment was expressly rejecting and overruling that. So this is one of those ones
exactly what it was doing.
where it was saying, no, if you're a citizen of the United States, you get this right. You get these rights. There's a certain number of federal rights, and states cannot impinge, limit, or eliminate those
Okay, let
rights.
me jump on that for a second. You're saying there's a certain number of federal rights
Yes.
that they get to choose. They essentially get to decide what those are.
Who?
The federal government.
The
Supreme
Constitution
Court.
does.
Okay, I don't think so. So here's an example, right? The right to privacy, is that a federal or a state thing?
That's a great question. So that
Does
is,
the Constitution tell us?
I
No,
think
the federal government did through the Supreme Court through Roe v. Wade.
Jeff thinks he's got me here, but I'm going to make an argument. Okay.
Turn off his mic. Turn off his mic.
There is no enumerated right to privacy. However, there are various privacy rights within the Constitution.
Okay.
There's the Fourth Amendment. There's Fifth Amendment. There is the First Amendment. There is the Third Amendment. And
But Roe v. Wade referred to the 14th Amendment, and they said we're creating privacy right out of the 14th Amendment because we, the federal Supreme Court, say it exists there out of the penumbra of rights.
I would say that's not quite what Roe v. Wade says,
Okay.
but I do agree
general.
with you. I do agree with you that the court in Roe v. Wade, and Jeff's already acknowledged that we both agree that Roe v. Wade got to the wrong place.
Yeah, we're
But they decided that there was a fundamental right to privacy that prohibits government from interfering with your body. And as a result of that, people had the ability to make certain, what they called fundamental decisions about their body. And they included one of those as the ability to carry a pregnancy to term.
Okay.
And I think the court made a huge mistake in this. And the mistake is, I think, is not that right exists. I think that right does exist. I think what the court did is the court failed to consider the right of the unborn child. And that there is an equal right, and perhaps a superior right, that states get to protect because they cannot protect themselves, that prevents the court from making that decision. So my concern with the court is not because of the right to privacy. It's with their ignoring the right to life, which is an express right.
Yeah, and so the way I'd respond to that is I think we're admitting that the court did created the right to privacy out of their decision, because they said there's a penumbra. In other words, there's kind of this misty thing where there's a right to privacy, and we're going to say that's a federal right. The federal government gets to decide on this. And I'm saying you can't pick up one stick without picking up the other. If you say that they have the ability, the Supreme Court, the federal government has the ability to define what those rights are in the 14th Amendment, because that is I mean, there's due process is equal protection, but the question is about which rights. And if you say, well, the federal government is in charge of those rights, and the federal government gets to decide what rights those are, then you get an abuse of power. And I think that's my main issue with Roe v. Wade and with Obergefell, is that the federal government stepped in and said, we're going to define what those rights are. They essentially gave themselves the power, just like way back in Marbury versus Madison. They created a very significant power that they gave to themselves because they decided to give it to themselves. And if you agree that they have the power to create that power and then to exercise it, well, then, yeah, the rest is history. They're on their way, and they can do a whole bunch of bad stuff. And I'd say, where do we get to the doctrine that they get to decide which rights are federal and which rights are states? They need to make sure due process and equal protection, that's in there. But to say, I'm going to create right to privacy, and therefore we're going to disallow abortions, where is that? To me, that's thin air.
One of the things that I want to point out with that is that Roe v. Wade didn't say that that was a federal right. What it determined is that was a personal right. And so this is where I would say what they're saying is the Ninth Amendment say that there are certain unenumerated rights which are reserved to the people, which the government cannot impinge and cannot remove because they are personal rights. And the right to privacy was talked about quite a bit before Roe v. Wade was decided. So you have the Connecticut case, you have the Virginia case, Griswold v. Connecticut, and Loving v. Virginia. And these are ones that are not involved with abortion, they're involved with other things. And the court decided those things based off of a right of privacy. And you also have other cases under the Fourth Amendment and under the Fifth Amendment where they had made decisions regarding the extension of those certain protections of the rights of individuals. Not the rights of states, but the rights of individuals against the incursion of state power. And the Supreme Court has consistently upheld those rights in the face of raw governmental power. And what the court said in Roe, and again, I think that they were wrong here, is they said that personal right for the woman outweighs all other rights. Whereas what the court should have done is said, no, we're looking at a balancing of rights. And because it's a balancing of rights, then it should go back to the state. And this is, I think, why Justice Thomas says that all of the substantive due process cases, and that's the cases like Griswold v. Connecticut, Loving v. Virginia, Obergefell v. Hodges, those were all substantive due process cases. And he says he's questioning the doctrine of substantive due process and saying we should reconsider all of those cases because they were decided under what he thinks is an erroneous legal standard.
That's he would say it much more eloquently. You probably did too, but that's exactly where I stand. Substantive due process is we've given ourselves a magic wand, and we're going to say, no. I think, I'll reiterate, I think it's really important the federal government had some more strength. The 14th Amendment had a purpose, but it's been pushed too far. It's been applied in much too broad a way. Yeah.
So we're going to enter our Q&A session. So audience members that do want to ask a question, get ready in here just a couple minutes to do so. I wanted to just conclude our debate with just one more question, and that is, we've talked a lot about some of the issues and how some people see, a state restricting same-sex marriage, for example, as a violation of equal protection, right? So my question for both of you is, where do you see tangible violations of the 14th Amendment, either under the Due Process Clause or the Equal Protection Clause that are taking place today, if any?
At the state level?
At the state level, correct. We'll start with David.
I see a lot of violations of the 14th Amendment. I really think that the 14th Amendment and the Equal Protection Clause are two of the things that are in most jeopardy today. And what I see is attempts by states to preference one group or one ethnic minority or one minority over another. So to me, there was a recent proposal, I think it was by the city of San Francisco, to provide reparations to long to African Americans who had lived in San Francisco for a long period of time. And they were proposing that those reparations should be to the tune of $5 million if they had been there for a sufficient amount of time. And
Per
this was-
person, right?
Sorry?
Per person.
Per person. And to me, that is blatantly unconstitutional, because you're basically saying this class of individuals get a different set of privileges than this class of individual. I think some of the efforts that you've seen in the news lately coming out of Virginia about not telling high school students that they have won certain awards is another one of those areas where it's truly problematic. You look at the Harvard case about racial discrimination against Asian Americans, or just Asians in general. I think that's an example of blatant violations of the 14th Amendment.
So you reject the 14th Amendment's use of upholding affirmative action in admissions or employment decisions?
I do. I think that is blatantly against what the 14th Amendment says. Equal protection, to me, means equal protection. It means you can't prefer and you can't discriminate. And to me, that is a two-way street. It's not something where we can say we're going to discriminate against one side for a while in order to make it fair.
Make sure you define what affirmative action is.
Sorry. Thanks. I asked them to try to keep me on my toes and stop using lingo language.
That was my bad, yeah.
So affirmative action is the idea that minorities that have been discriminated against in the past should be preferred in certain decisions. And so one of the places that the Supreme Court has for now expressly allowed race, which is a prohibited classification. In other words, we're not supposed to make decisions based off of race. But the Supreme Court has allowed race to be a factor that is considered in admissions, provided that it only goes in one direction. And that's typically what's called affirmative action. It can be done in race. It has been proposed or has been done in employment and other things. And I think all of those are unconstitutional.
Jeff?
Yeah, I don't want to sound too insulting to any federal people out there, but I think there are a bunch of challenges. But I certainly don't think the federal government or the Supreme Court are the only people who have brains that can figure out those challenges. I'd rather have those figured out at the local or state or county level. And is it a little more messy? Maybe. But if you have 50 different laboratories and 28 get it right and 22 get it wrong, I'd rather have that be, and then I still have the freedom to choose and move to a different state, rather than, we got one decider, it's the federal government. If they get it wrong, then we abort 53 million babies since 1973. Like, wait a second, that's not a self-government idea. So I think there are problems. I think the remedy is not centralization of power, it's dispersion of power. And those things will fix themselves more quickly when more people are empowered and that power is divided and separated, and the principle of federalism is followed. Then we'll be more free and not just subject to, when it all boils down to it, 5 men or women in black robes saying, here's how it's going to be. You can say that, but you're only one of the players. The real players is America, the people, through their states, through their counties, through their cities, through their families, fixing all the problems, not just saying, what's the federal government say?
Okay, very good. Let's give our debaters a round of applause. Okay, we're going to open up. We have about 20 minutes left of time, so we're going to just open up the last part of our evening for Q&A. So if you would like to ask a question, go ahead and just line up over here on the steps. Make sure to speak clearly into the microphone so that our remote audience can hear. And we'll go ahead and start with our first question.
Okay, so there was a lot of talk of Roe v. Wade, which I've done a lot of research on. And I was just curious, there was also a lot of talk about our rights to, about the federal government protecting our rights to life, liberty, and property. And Mr. Hymas touched on giving the rights back to the states to determine like abortion or things like that. But I was just curious, if we did do that and some states which has happened, have decided to protect abortion rights, wouldn't that be infringing on the life of the child? And our federal government was put in place to protect those rights. So do you think the federal government should be involved in that?
Go ahead.
I was going to say, I think that there is a point where the federal government should be involved in that. And I also do think that there is a point where the rights of the unborn child outweigh the rights of the mother. And exactly where is that point is I think is difficult to decide, which is why the court said that should be something that's decided by the states. But I do think that the rights of the unborn child are very, very important. But I'm also, I don't know, this is a place where I think I'm perhaps a pragmatist or a practicalist. When you're talking about a life that has not yet been born, in other words, we don't know whether the baby will survive, there is a question as to whether that life outweighs the life of a person that we do know is surviving and is living. So that I think that there are certain circumstances where that calculus doesn't work out. If the life of the mother is in danger, you know that the mother is going to survive. You don't necessarily know about the unborn child. And so there is some weighing that I think that can take place there. And that is something that I think the federal government could do. The Supreme Court has decided otherwise. This is a place where I think that Roe v. Wade was a very bad decision. I think that Dobbs has problems because I do think under the 14th Amendment there should be some protection of the right to life. And where do you do that, and what is the case that would raise that up appropriately? I'm not really sure. But I think that if Congress was to act to decide that there was to be certain protections, that I think that they would have that ability if they were to act under the 14th Amendment, Section 5, because they have been given the power to protect life.
Or conversely, to legalize abortion nationwide.
I have a bigger problem with legalizing abortion nationwide, and this is where my fundamental prejudice and my belief of substantive due process as a real thing does come in. I think that Congress has the ability to go one way, but not necessarily to go the other way. And so when you read the Roe v. Wade decision, they just have a difficult time pointing out any justification for the way that they balanced the two lives. Whereas if you try to go the other direction, I think that there's much greater justification. So, that's one where I think that the logic points in a single direction and not a two-way direction.
I think the way you worded that is really interesting, and it's leading, right, to say, look, if the federal government's job is to protect life, liberty, and property, then shouldn't the federal government jump in and protect that child's life? I agree. We both see the same moral issue there, but since 1973 up till now, which is, 50 years or whatever, a few people in the Supreme Court didn't agree, and so millions of babies were aborted. As much as you and I feel morally the same about abortion, it's hard to imagine, but there's about half of America who feels just as strong morally about the right of a mother to her privacy. And I would rather not throw that into one court that decides for the whole land. I'd rather put it into the states and rely on the goodness of the states and the goodness of the people spread across America to make those decisions. And if people in New York make the decision to abort all the way up to the day of birth, they do, but I'm not locked into it. I can leave New York and go to a place where I commingle with people who have the same morals and values that I do. I think that's a better option. If you put it up to the Supreme Court and they rule wrong, you have no choice. Abortion's legal everywhere, and then you're stuck. And I think that Jefferson said, I'd rather be exposed to the inconveniences of attending too much liberty than the inconveniences of attending too small a degree of it. In this case, as much as, it's hardly even political, right? It's like, this is morally at my foundation. We got to make this stop. We do. But putting it at the federal level, I think, at least over the last 50 years of our history, says that's actually not going to help anything. That's going to kill millions of babies. So I would say, as much as I'd like them to make the right decision, let's move it down to the states so that it's dispersed.
Thank you. Next question.
Okay, so I was doing a little bit of research on my question. question because I want to make sure I was getting this right. But my question is, should felons have the right to vote? Almost half of our states have something called automatic restoration of their rights for felons who get released. And in some states, you can still vote even while in prison. So some states like California require voter registration for formerly incarcerated people. But California, just last December, it released thousands of convicted pedophiles that had less than a year of prison time. And I was wondering, should we respect their rights despite them most likely not being reformed or willing to comply with the laws that they are subject to?
Can I jump in on this one? I'm not well enough informed on this to answer that question, but I know that whatever California agrees to, I'm against that. Sorry, I have a bunch of cousins and grandma and grandpa who are in California watching this. Sorry, guys, but anyway.
I'll try to answer that. Under the Fifth Amendment to the United States Constitution, government has the ability to remove pretty much all rights, provided they're done under due process of law. And part of that means through a process whereby someone is accused, they are notified, they have the right and ability to call witnesses, they have the assistance of counsel, and they are duly convicted by a jury of their peers. Upon those things, all of those rights, life, liberty, and property, can be removed by the state. And so I would say lesser rights include the right to vote. And so I think that states can remove the right to vote from convicted felons. I think they could remove the right to vote from convicted misdemeanors. If the state chose that that's what they wanted to do, I think that they could do that. Because there is due process in that process. I mean, it's kind of repetitive, but the process, the way that is done is fair. They have the laws are published. They know what laws they're breaking, and there is a fair process consistent with the requirements of the Constitution of the United States and the constitutions of the state, whereby they are convicted and those rights are removed. Now, there may be a process whereby those rights can be restored. Some states have that, other states don't. But I have no problem at all with a state removing rights from individuals, provided they do it under due process of law.
And if I might add just one thing, I think this is a great question because, for one thing, it really cuts to the core of the 14th Amendment, and also demonstrates some of the ambiguity, right, or openness in our Constitution or in state constitutions that are very clear about how rights can be taken away, but are very unclear on how those rights can be regained, particularly after a conviction, right? And so there's a lot of concern amongst the public that ex-felons essentially have no chance, particularly because they often have to reveal on a job application if they are a felon, right? And so it's difficult to get a job. They're not able to vote. Essentially, they're outcasts once they're released. So I see the concern that people have regarding this ambiguity and the inability to retain rights after one is released and is able to go free. It's certainly a challenge.
And just to jump on top of that, we can remove the rights only with due process, but ironically, the stroke of a governor or president's pen could restore them because they could be completely pardoned, and it's as if that crime had never happened.
Right.
And all of those rights are restored not through perhaps what we would call due process, but by the decree of a governor.
But that's only if you're able to adequately lobby that governor or president, which is which is the exception, not the rule.
And sometimes there's been some concerns that presidents or governments have acted arbitrarily in choosing who to restore rights to and who not to.
Can I follow up with a question? Because that's I guess what confuses me, David. If you say, I'm fine with states, because you're saying you're fine with different states allowing felons to vote or not vote. But then, aren't you arbitrarily saying, well, because then I would say, well, I think voting rights for felons is a federal issue.
It is. It's absolutely a federal issue.
But you just said that each state should be able to decide how to do it.
Yes, because the Fifth Amendment allows those rights to be removed through due process of law.
So if one state says felons can vote and another one says felons can't, the Supreme Court should come in, or the federal government should come in and say, you have to do it our way.
No, they just have to make sure that the process is due.
Yeah, and
In other words, that it's
where,
fair. So
That's where I think
a criminal conviction has to comply with constitutional standards. You have to have a unanimous jury. You have to have the possibility or the reality of a grand jury indictment. You have to have a notice and an opportunity to be heard. You have to be able to have the assistance of counsel.
and those are categorized as something called due process.
Those are part of the things which are due process. They're not the only things that are due
They're
process.
the process that's due any person in order to be convicted fairly.
Yes. And as a
That's
result
due-
of
that's
that,
like procedural due process. Like, I get that.
Yeah.
But then substantive due process all of a sudden says, well, anything else that we decide to. And I don't know. You and I are probably going way too far.
substantive due process, this is where I get down into the weeds, and I asked them to try to keep me out of the weeds.
We can stop.
Is a different thing.
Yeah, okay.
Yeah, get out of there, get out of there. Great question,
Thanks,
thank you.
Cara. Yeah, those are two great questions.
Go ahead.
Okay, I'll go down lower.
Sorry.
That's okay, it's good. So my question has to do with original intent, because Jeff brought that up. So this wasn't originally a question for you, but we'll see how it goes. So I love the idea of, when discussing original intent, the founders, at least in the Virginia plan, decided on a legislative veto, legislative negative, which meant that the federal government could strike down every single state law if they didn't like it. And that was the original concept, right? And there was some debate, and they eventually rejected the idea, and it was suggested that it should become the jurisdiction of the judiciary. So that should be the judiciary power. So it's interesting to me that when the 14th Amendment, because you talk about this as a second founding, the 14th Amendment, instead of having this idea that that Congress should be able to get rid of any law they didn't like and reject that, they decided that they should have the power to write any law that they wanted for the states. So I'm just wondering how you let me read my question. But I'm just wondering how you reconcile this idea of this positive power, is it an overreach of unrestricted jurisdiction and not necessarily an extension of the founding, but the complete opposite of what the founders thought?
I think that this is an extension, although what I see the 14th Amendment do, and when I particularly look at Section 5, is it's a new express power of Congress. So whereas before you have, and Jeff can correct me here, you have clauses 1 through 23
What are we talking about?
of Section 8, Article 1.
18. Yeah.
18, 1 through 18. I knew that he'd be able to correct me on that. 1 through 18, and their various affirmative delegations and express powers to Congress. And with the 14th Amendment, Section 5, you have another express delegation of power. I do see that there is a restructuring of federalism, but not a restructuring of the checks and balance between the three branches of the federal government.
Can I respond?
Yes.
Just because I think there's a difference between saying we can strike down laws to we create our own laws, right? There's a complete difference of power, and I would say it's not even a restructuring of federalism so much as a deconstruction of federalism.
I would agree with you, because what they're doing is they're weakening the power of the states, and they're enhancing the power of the federal government. And so the states come out of this after the 14th Amendment much weaker, whereas before they used to be equal to, or even in some cases superior to, the power of the federal government, which is why the Latter-day Saints were driven out of Missouri, because the federal government had no ability or power to intervene. Well, today there's no question that the federal government would have the power to intervene under those circumstances. And so I think you really do see a restructuring. And whether you call it a deconstruction or to me just a raw grant of power, doesn't really change the way that the three branches of the federal government interact with each other. What it changes is the way that the federal government interacts with the state governments.
And I'll just give like a first grade analogy because that's where my level of intelligence rises to. But if the federal is here and the state's here, I think the 14th is super important to make sure they went like this. But it did not go like this. There's no question, like David said, they for sure should step in and prevent what happened to the members of the church. Because the states, did I say that wrong? The states were here and the federal was here. But they got brought down to an equal playing field because it was unbalanced. And I think how it is today, it's unbalanced the wrong way. That doesn't fix anything. That just causes more problems. So adjustment had to happen, but it's an overzealous adjustment that's not justified to me in the original intent, to me in common application of current events. So I'm not really answering your question, but I'm just talking in general terms that.
That's good.
Thanks for your question. We'll have this be our last question of the evening.
All right. So, how does affirmative action, well, I guess it's kind of going against what the 14th Amendment is saying about equal rights for everyone. And also, like, who decides which groups get the affirmative action? Because you could, like, make up any group to decide who gets it.
Well, I think the three of us for sure are against affirmative action on that very point. Like, wait a second, that's not equal protection. That's like an unequal protection. Like you're using extra. The point being that who gets to decide that is apparently the federal government, right, Dave?
Just United States Supreme Court.
Oh yeah, that's
my
always the
answer.
That's right.
That's my answer for who gets to decide everything, right?
Yeah, it's the wrong answer every time, but he keeps using it every time.
Ow.
No, so yeah, there's affirmative action. Yeah, we all agree that that's an incorrect application of the Equal Protection Clause, and it is it's derived. It's a created bad thing by the Supreme Court.
So stop me if I start sounding too much like a lawyer, but what the courts have done... Okay, stop. Jeff said, just stop right there. What the courts have done is they have created what they call protected classes. And these are groups that are entitled, let's use that word loosely, to enhanced protection. And that's not even correct. I'm trying to talk where everybody can hopefully understand me, but enhanced protection. And if you belong to a protected class, then any action that people take against you is viewed very suspiciously by the courts. But if an action is taken that benefits you and perhaps is unfavorable to a non-protected class, then those are not viewed suspiciously. And so what that creates is kind of this de facto situation where if you belong to a protected class, that you can receive certain degrees of favoritism, whereas those that don't belong to that protected class can receive certain degrees of discrimination without having them scrutinized or looked at really closely by a court.
And if you don't mind,
Please interpret for me.
Just because Jeff said the three of us, so I think it's important to clarify since he was pulling me into that. I actually am not totally opposed to affirmative action, right? I think historically, and I realize that it's a logically inconsistent position that I'm taking, but I think I kind of agree with Lyndon B. Johnson's perspective that you can't simply have a group of people who's been hobbled by chains and expect them to compete and with the white man who had owned property all those years before, who had had all the positions in the medical field or all the positions in the legal field, and expect them to compete on an equal footing for lawyer positions or medical doctor positions moving into the future. And so I think there was at least a temporary need for affirmative action post, the civil rights era, the Jim Crow. And even though constitutionally I think affirmative action does in fact it's questionable whether or not it is in line with the 14th Amendment, especially now. And I think that's where the court is going to look at affirmative action, because affirmative action was always meant to be temporary, to address historic wrongs against people of color in the United States, right? And the question is, has it done that? And if it hasn't, when will it end? When will it have achieved the objectives? And so the other thing to consider is that there's different levels of affirmative action, right, that are completely in line with the 14th Amendment. For example, sometimes organizations will simply advertise their job to groups of people that have historically been disadvantaged, only to increase the applicant pool so that there is a higher probability that there will be more minority candidates for that position. That is affirmative action, right? Does it show preferential treatment for those candidates after that? Not necessarily. Not all organizations go further than that in trying to apply an equal standard or give historically disadvantaged groups an equal footing for a job, for example, or college admission. But some, in fact, as David suggested, do in fact show preferential treatment, and that's where a lot of those questions lie.
I thought we all thought the same about this. Sorry, so I wanted to make sure.
We might need to do another night.
Yeah.
Yeah, I think
Affirmative action, right?
We got to have Adam debate Jeff. That's what we need.
It's all right, Dave. No. I think in general, I'm against affirmative action, and I'm very, very nervous about protected classes, because I think all those things are unnatural. They go back to social contract type ideas instead of natural law type ideas.
Those are the correct ideas.
The correct ones, as approved by or determined by the Supreme Court. So anyway, I think affirmative action and protected classes, I think, gives government a power that is unnatural. It doesn't mean that we don't have issues we need to solve, but you don't solve an issue the government created by government trying to solve another issue. That just leads to more government, more problems, and more government, more problems, and more government. I think that's a vicious cycle. So it's a good question. I thought affirmative action was kind of a quick little thing, but there's actually quite a bit to it, and it applies very well to the 14th Amendment. So that's a good question.
Thank you. Let's go ahead and give our questioners and debaters a round of applause. We are so grateful to those of you who joined us this evening for our discussion. Thank you so much. We also want to thank those who will watch this later and joined us remotely. We also want to thank our AHS school administrators, Jay Clark and his team on the technology, and others who assisted in making tonight possible. Our next event will take place, and mark your calendars, 2 weeks from this evening. So our next Literacy Series event will be on February 10th at 7 p.m. here in this auditorium. We will be debating the school choice bill, which I know many of you have perhaps heard about or been following in the news, which just passed.
HB 215.
HB 215, yep, which just passed both houses of the Utah State Legislature. We invite or encourage you to invite your friends and neighbors so that they can also benefit from these events. To watch previous sessions and for other resources, make sure to visit constitutionandcivility.org. We hope to see you next time. Thank you again, and good night.